let's start. Sanjeet, good to have you here. And I think everyone knows that apart from being a wonderful lawyer, you're also an author. And your work has been on environmental law. So everybody knows that you are possibly the last word on environmental issues here. Let's hear Sanjeet. I don't know if there's uh, correct. Oh, Salman said that, sir, can we discuss any topic other than law? But I thought today's discussion was scheduled to be environmental law. So we'll figure out. Yes, of course, we would any day have sessions and issues which would be other than law. More than happy. In fact, most of you know me more than that I'm the last one to be, to say no to things other than law. In fact, a lot of people still question me to be whether I'm a full-fledged lawyer at all or not. Yes, Sanjeet, over to you. Please share with everyone with your own vast experience. Over to you.
Thank you, Vikas sir. Thanks for this very brief but very over-projected introduction of mine. I don't feel that I am the last word in environmental law. I have few words. I know that I have few words. Yeah. So good morning, all friends.
Sanjeet, I'll just interrupt you for a minute. Please, everyone, can you keep your microphones off so that we don't have any disturbance via the speaker? Thank you. Yes, Sanjeet, please.
Yeah, as we all know that today we are celebrating Mother's Day. So वैसे तो हर दिन माँ से शुरू होके माँ पे ही खत्म होता है, but we don't often get that opportunity to say I love you mom, I thank you mom. But today is a special day where we can say it. So I have chosen this day. I requested Vikas Bhai to give me this day so that I can say something and I can dedicate something to the mother of all mothers, that is our Mother Earth. Thanks to Sunil Beniwal Bhai also, who has spared his space for me. So today's deliberation and discussion is on the environment. So it's dedicated to Mother Earth. So first of all, I should say thanks to Vikas sir for holding this lecture session. Vikas sir is known for his active and innovation. He has kept his streak alive. And during this lockdown, he has provided this platform for various open discussions. And I think various new lawyers have benefited from that. So thanks a lot for giving this podium to me today. Without wasting much time, I should jump on my today's topic. And today's topic is evaluation, facets, and prospects of environmental adjudication in India. So it has three different parts of my discussion. In first part, I would try to describe the whole history of evaluation of environmental law in India. In second part, that is the facet part, I would try to explain the relevant provisions of National Green Tribunal Act 2010. And in the third part, that is the prospects, I would try to explain the contribution made by the NGT till date and the challenges faced by the NGT. So two disclaimers before I proceed. First, that at each point of time, I said that I would try to explain the evolution, facets, and prospects. So I'm just making an effort with the best of my ability. And I present myself in front of all of you for a fair assessment of mine. You all are free to give feedbacks to me. I would love to improve myself. And secondly, I just seek a little liberty in terms of language, because I know myself when I go in flow with my heart, the Hindi automatically comes out. मैं और मेरा दिल दोनों ही हिंदी मीडियम में पढ़े हैं. So I would like to have that liberty from you, Vikas bhai, that if something comes in between, you have to pardon me for that. So coming to this evolution part, environmental rights are also a part of the human rights. However, these rights are having relatively a recent history. If we see in an Indian perspective, we got independence in 1997, we got our constitution 1947, and we got our constitution in 1950. But if you see the original draft of Indian constitution, the environmental right as a right or duty was never been a part of the original constitution. As a matter of fact, if we see in the perspective of international human rights, the environmental rights are placed as a third generation human right. So the first generation human rights are civil and political rights. Then second generation human rights are social, economic, and cultural rights. And the third generation human rights are the rights to have the safe and hygienic environment. So after independence from the British rule, the first priority before the government was to ensure the basic things to its citizen, just like the roti, kapda, and makan. So environment was never been a focus of the our government. However, if we want to trace the history, the beginning point, the starting point of environmental concept of environment being introduced in our legal system, then the starting point was Stockholm, the United Nation Conference on Human Environment at Stockholm in 1972. That was a historical moment when our very active and energetic Prime Minister Indira Gandhi took part in the Stockholm Conference. This was the point when the India has shown its commitment to recognize and to ensure environmental rights in our country. So there is a very nice picture, very popularly being displayed at many point of times, that the Indira Gandhi ji is taking part in the Stockholm Conference. So this conference has culminated in passing of a declaration containing 26 principles and an action plan with 109 recommendations. So a duty has been casted on each participating country to ensure the human rights in their own countries. And each and every participating country, including the India, has committed that they will have some law in place in their country to provide for the environmental rights to its citizen. So immediately after taking part in the Stockholm conference at 1972, the first action which was taken by the Indian government was the introduction of 42nd Amendment in 1976. It is in the Constitution. It is for the first time that the Indian Constitution had some provisions with regard to the environment, and those provisions were the Article 48A, that is the directive principles which cast duty upon the state government states to do something on the environment, as well as the Article 51AG, which provided the fundamental duty of the citizens to take care of the natural resources. So I would request each and everyone to have a small piece of paper as well as a pen in the hand, so that you can note down some of the provisions and the judgments, because I'm not going to read out all the provisions and judgments. So you can have that in your homework. So for the first time, this in 1976, the Article 48A and Article 51AG was introduced in the Constitution of India. If we see with regard to the statutory part, that after the 72, the first act on the environment which was enacted by the Indian government was Water Prevention and Control of Pollution Act 1974. So this was all post Stockholm Declaration. Thereafter, there was an act of Water Cess Act that was in 1977. The significant feature of Water Act was that has, for the first time in India, has created the bodies like State Pollution Control Board and Central Pollution Control Board. So this has been established under the Water Act. Thereafter, two very good. Apart from that, one more significant amendment which was introduced in 1976 was that the issue of forest and wildlife was being shifted from state list to the concurrent list, and therefore even the central government and state government both were being given the power to have their own laws on the issue of forest and wildlife. So this was another constitutional amendment which was done in 1976. The two significant enactment which came into existence in 1980 was the Forest Conservation Act, and thereafter the Air Act in 1981. So you can clearly see that each and everything has started coming in place after the Stockholm Declaration in order to execute the commitment made by the India on the international platform. Thereafter, a biggest tragedy, the first ever biggest tragedy, environmental tragedy, happened in Bhopal gas tragedy in 1984. And the government of India has realized that these Air Act and Water Act are not sufficient to deal with the various different environmental positions and the eventualities which may come in front in future. And thereafter, it was decided to have a umbrella legislation. And being awake of the same, this Environmental Protection Act was being enacted in 1986, in which for the first time few criminal liabilities have been created, as well as one very popularly used provision is Section 5 of the Environmental Protection Act, which gives power to the central government to issue various notifications. So if we see that various notifications, be it environmental clearance notifications, some notifications being issued with regard to the coastal zone regulations and all, so all these have been issued while exercising the powers under Section 5 of the Environmental Protection Act. It has been decided amongst the international community that we will meet after 20 years, every 20 years. So the first United Nations conference was in Stockholm in 1972. Then 1992 was a conference at Rio, and thereafter again a international conference in Rio in 2012. So each 20 years, after a lapse of 20 years, they meet, they decide the future course of action for next 2 decades. So one big step was taken by the international community, that is while passing the Rio Declaration in 1992. Rio Declaration was important in the sense that for the first time the concept of environmental democracy, this particular word has been coined in 1992, and they have said that each and every state must ensure environmental democracy to their country. It means they have to give access to justice, access to information, and third is public participation. So these three components has to be assured by each and every country to their citizens. Principle 10 of the Rio Declaration is very talked about and very important. All of you are requested to read the Principle 10, and you will find these components somewhere and this concept of environmental democracy there. So after the commitment which has been made by the India in Rio, the first step which has been taken by the Indian government was passing of environmental clearance notification 1994. So after 1992, 1994, environmental clearance notification has been passed, which for the first time has provided the right of the stakeholders to participate in the decision-making process. The concept of public hearing was for the first time being introduced in India by way of environmental clearance notification 1994, and this is how the third component, that is the public participation, has been ensured by the India. Later on, what happened that the first COP, the climate change conference, was held in Berlin in 1995. Indian government was to take part in the said conference. However, in order to provide access to justice, no legislation was being enacted by the Indian government by that time. So since they had to take part in that particular conference and they had to show that they have done something in pursuance of the Rio Declaration, so in very urgent circumstances, very hurriedly, a law for establishing the first environmental court, that is the National Environmental Tribunal 1995, has been passed in the form of an ordinance. So an ordinance has been passed to create a tribunal in 1995, and the preamble of the said National Environmental Tribunal says that this is the tribunal which will deal with all the cases to provide the compensation and damages in the environmental cases. And after that, passing of that ordinance, they have taken part in the international conference. They have shown that we have done this. Later on, the act itself has been passed, but unfortunately, the National Environmental Tribunal has never ever been constituted. The tribunal has not been notified. The tribunal has never been constituted. No chairperson, no member has ever been appointed, and it was an act which was enacted but never been implemented. So this was the failure of Indian government in not providing that platform. Parallelly, in 1997, one more tribunal, one more forum has been created, and that was the National Environmental Appellate Authority Act 1997. So this particular appellate authority has been constituted to hear all the appeals with regard to the order passed by the pollution control boards in relation to the cancellation or grant of consent to operate and consent to establish, as well as all appeals against the environmental clearance being granted by the central government or the state government. So this appellate authority was being constituted in 1997. Mr. N. Venkatachala was the first, the retired Supreme Court judge was the first chairperson of this particular tribunal. By the time this appellate authority, by the time this appellate authority was constituted in 1997, its service regulations were not framed. So when the first chairperson N. Venkatachala was appointed, there was no service regulations and salary structure was not there. So while protecting their pay and their status as a retired Supreme Court judge, the same salary and status was being given, and Venkatachala has continued as a chairperson of that appellate authority from 1997 to 2002, that is the 5 years tenure. The second weak part of this particular tribunal was that for the expert members, no specific qualification was being prescribed. So what happened that some of the persons were not even having the experience or technical expertise of particular subject, but just being a member, a bureaucrat, being working in the Ministry of Environment and Forest, they got the assignment of becoming a member in the NEAA. In the meantime, what happened, that is very important, that in the meantime, what happened, the service regulations have been passed and the government has prescribed that all the persons, chairpersons and the vice chairpersons will be having the rank and status of a secretary in the government, which is much below the rank of a retired Supreme Court judge or High Court judge. So it so happened that after 2002, none of the Supreme Court judge or a High Court judge has given his consent to become a chairperson or a vice chairperson of the particular authority. So since 2002 up till 2010, when the NGTS came, this particular NEAA has worked without a chairperson or a vice chairperson. So for good 8 years, only few of the expert members have run that particular appellate authority. And the worst part was that for the entire India, there was one NEAA having the sitting in Delhi. So from anywhere in the part of country, if you want to file an appeal, you have to come down to Delhi. So the access of justice was largely being denied in that authority. In the meantime, what happened that since some of the expert members were not having the technical experience, over the period of time, it has been realized that almost all the appeals which have been filed have been dismissed on very flimsy and non-legal grounds. And each and every order of NEAA was being challenged before the Delhi High Court under the writ jurisdiction. And the Delhi High Court was constantly looking at all the judgments being passed by the NEAA and was felt very pity the way in which this authority was functioning. So this has given rise to a very big case of Vimal Bhai versus Union of India in 2009, which was decided, but it has continued for 2 long years. So in that case, the court has shifted its focus from the merits of that case, but started looking at the functioning of the NEAA. And the Delhi High Court has said that we have to look into it, that the way in which this authority's function is quite pathetic. In the meantime, what happened that since I was also a part, somewhere in a part of that litigation, various RTIs have been filed in the NEAA to know that what are the technical qualifications and the expertise and the background, the educational background of these members. And it was found that none of the members were having any technical experience or a specific degree in that subject. Few of the people were having some diploma, but few were working as a secretary in the MOEF and CC were getting that assignment. When it has been passed, when it has been asked that what exactly they are subscribing as a literature to update themselves on environmental subject, the RTI has replied, they have replied in the RTI that there is a magazine called Gobar Times that we subscribe. So there was a small NGO which brings out this Gobar Times, but this was the only literature which they were subscribing, this Gobar Times. So it was quite shocking, and all those facts were brought to the knowledge of the Delhi High Court. And Delhi High Court has passed a very detailed judgment pointing out all the deficiency and their pain with regard to the functioning of the NEAA. And they have said that this is not the way in which authority should function. And they have clearly, in very bold terms, have said that they have failed to achieve its objectives. In the meantime, what happened that appeals were going to the NEAA, but all the original side matters which were not in the manner of the appeal were regularly being going to the High Court. And the High Court under its judicial activism, has dealt with many environmental matters. We have seen the series of MC Mehta, we have seen very big judgments in the environmental side being passed by the Honorable Supreme Court. That has in various PIS that has laid down the law with regard to the environmental law in the country. However, at many point of time, even the Supreme Court of India as well as the High Courts have reported their limitations. The limitations on two fronts. First is the power of judicial review. They have said that we are not the appellate authority, we are only having the power of judicial review. So we can only review the process, but we cannot comment on the merits of the case. And secondly, at many point of times, they have found that they are not having the expertise to say something on the merits of the case or to say something about the subject. So they have, like there are series of judgments. I will give the list and I think Samarpit is going to circulate amongst you all. There's a 1986, the judgment of MC Mehta, the 1999 AP Pollution Control Board, the 1996 Indian Council for Enviro Legal Action, and 2001 AP Pollution Control Board versus MV Naidu. These were three judgments in which the Supreme Court of India has boldly said that this is the time when India need a specialized forum, a specialized court, tribunal, having the judicial as well as the technical members who should deal with the environmental matters. So this was the need expressed by the Supreme Court of India itself. Parallel to this, the Law Commission in its 186th report has also recommended the same thing, being aware of all the situations and the problem being faced across the country and the failure of the NEA at the one side. Secondly, the need expressed by the Honorable Supreme Court. The Law Commission has also recommended to the government that there is a dying need of some kind of tribunal. So this is the whole background in which the environmental law, means the substantive law, has been developed, and how two tribunal being constituted but failed to achieve its objectives, and the need being expressed by the Honorable Supreme Court. And this has given rise to the enactment of the National Green Tribunal Act. So in 2010, we got this act, the National Green Tribunal Act, and the preamble of the National Green Tribunal Act is very important. You all should read it. It clearly says in the preamble part also that in order to implement the commitment made by the country in the Stockholm Declaration as well as in the Rio Declaration, and in order to ensure the Article 21 right to life in a justified manner to its countrymen, we are enacting this particular law. So this is very important in that sense. Now I would deal upon some of the provisions. I will briefly give an idea of those provisions, and you are free to read on your own in detail. So always the applicability, so it is applicable across country, and the jurisdiction is divided in 5 different benches. We have one principal bench at Delhi, then a central bench at Bhopal, one bench at Pune, one bench at Calcutta, and one bench at Chennai. So this is how the jurisdiction of the entire country has been divided. Although it is many a times demands have been raised by the various states that they should have one bench in one state at least, just like at every where the principal bench of the High Court is situated. However, as of now, we have only 5 benches. Now, some of the provisions which are relevant is the definition part is always very relevant in each and every legislation. So the definition of environment has been given in 2C, which covers each and everything, perhaps. And then the definition of section 2J, person. The definition of person is very important, because in various judgments being passed by the Honorable Tribunal, the 2J has been referred, and while giving reference of that 2J, they have said that a vast definition of person has been given in 2J, and therefore the locus standi before the NGT is very lenient, very relaxed, and each and every person who thinks that he have some concern about the environment can come forward and file a petition before the NGT. So 2J is very important. Now comes section 2M, substantial question relating to environment. That is very important. A particular a definition of this term called substantial question relating to environment has been given, which says that anything which affects the community at large, or an individual or a group of individual. anything which creates a gravity, which gravely damages the environment or a property in substantial manner, or any damage to the public health, which is broadly measurable. So three criteria have been given, and if something like that is being done, then you can say it is a substantial question relating to environment. And when there is a substantial question of relating to environment is there, or if you establish a substantial question relating to environment, then you can maintain a petition on the original side under section 14. So to invoke section 14, this particular definition is very important. Then, so these were the broadly the important definitions. Then we come to section 4, the composition of tribunal. That is very important because composition requires a full-time chairperson. That should be a retired Supreme Court judge. Then not less than 10 and maximum 20 full-time judicial member. Then not less than 10 and maximum 20 full-time expert members. So it will always be a combination of the judicial member and the expert member, and the minimum and maximum limit has already been prescribed. So far as seats are concerned, I've already told that I already said that there are 5 seats, 5 different benches of the NGT. Section 7 is very important because in the later part, when we will discuss about the challenges being faced, this will be of very relevance. That section 7 says that the maximum tenure of a chairperson or an expert member or a judicial member will be 5 years or up to the age of 70 years in case of Supreme Court judge, 67 years in case of a High Court judge, and 65 years in case of an expert member. But the 5-year tenure has been given to each and every member there. So this is how the composition of the tribunal is there. Now we come to the jurisdiction part of the NGT. So there are 3 different kind of jurisdiction which NGT enjoys. First is the original jurisdiction, second is the compensatory jurisdiction, and third is the appellate jurisdiction. So far as the original jurisdiction is concerned, so that comes in section 14, and which says that where there is any substantial question relating to environment is existing, any person can directly approach to the NGT invoking its original jurisdiction. This particular jurisdiction is akin to the jurisdiction which the high courts were exercising in the PIL under Article 226 or under Article 32 by the Supreme Court. So this particular jurisdiction of the High Court and Supreme Court to have the original jurisdiction to entertain PIL in the environmental matters have now been shifted to the NGT. This is the section 14. So far as section 15 is concerned, that provides for the compensatory jurisdiction in order to provide the relief, compensation, and restitution for the damages caused by the in the environmental matters. As I have told you that at first in 1995, the NET was established, National Environmental Tribunal, in order to provide the compensation for the environmental damage. But that particular tribunal was never constituted, and that is the main reason that the law with regard to the damages in environmental matters was never developed in India. Like, we were not having any criteria, we were not having any set formulas and judgments as a guiding principle to decide that what should be the compensation in an environmental matter, because the value of a tree for me is different and the value of a tree for somebody else who is taking shelter or somebody who's taking the forest produce is absolutely different. So there has to be a law, a guiding principle to know that what should be the level of compensation to be awarded in such cases. But that law was not developed because we were not having any such tribunal in that sense. But now over the years, under section 15, the manner in which the judgments have been passed, we have some guiding principle. So section 15 is very important so far as this particular compensation part is concerned. Section 16 is the appellate jurisdiction of the tribunal, which gives out a whole long list that what all orders are challenged, can be challenged before the tribunal in its appellate jurisdiction. As this is very important, that is for the first time this appellate jurisdiction has been given, because the high courts were having a limited jurisdiction of judicial review, where they can only check the process but cannot comment over the merit of the decision. They cannot question the opinion expressed by the experts. But now under the appellate jurisdiction, the jurisdiction is quite vast, and NGT is seen and have done the analysis of the opinion being expressed by the experts, or have also decided the questions with regard to the merits of the decision. So this is very important that we have a statutory appellate remedy in terms of section 16 of the Act. Now we come to section 19. This is the procedure and power of the tribunal. You have to go through the entire list because this gives a lot of other powers to the NGT in order to pass interim order, in order to review its own order, in order to restore the petition if being dismissed in want of prosecution. And there are many other provisions being given, and they also give the power to call for documents. They also give the power to call for the expert advice in some of the cases. So all those miscellaneous powers have been given under section 19. Now, a very significant provision under the National Green Tribunal Act is section 20. Section 20 says tribunal to apply certain principles. The tribunal shall, while passing any order or decision or award, apply the principles of sustainable development, the precautionary principle, and the polluter pays principle. So these were the well-established international principles: sustainable development, polluter pays, and precautionary principles. But they were in part of some of the conventions or some of the international documents, but not having their strict mandatory application in India. However, by virtue of section 20, for the first time, these international principles have got the statutory recognition. It means that now these international principles can be implemented in a mandatory form in our country by virtue of section 14. There was a judgment being passed by the Honorable Supreme Court, by the Honorable NGT in the Yamuna cleaning case, where they have issued a direction that nobody should put debris along with the bank of the Yamuna. And if you go to Delhi nearby the bank of Yamuna, you will find various hoardings lying there. That was as a part of the direction issued by the NGT, in which it says that अगर कोई ट्रक कोई भी मलबा यमुना के अंदर डालता हुआ पाया गया तो उसका ट्रक जब्त कर लिया जाएगा और पल्यूटर पेज प्रिंसिपल के तहत उसके ऊपर इतने रुपए का जुर्माना लगेगा. So it has got that level of recognition that even the truck driver, even the khallasi of the truck knows that there is something called polluter pays principle by which we can be made liable. So this is the beauty of this particular provision, that all those principles which were earlier being found only in the international documents are now being made implemented in India in its mandatory forms. So this was the beauty of section 20. Now coming to section 23, that is the cost, that the tribunal has the power to impose cost on any vexatious petition. So and as well as nowadays we have seen that many a times it happens that a person applies before the NGT by way of filing something, but later on under some pressure or under some allurance they want to withdraw the petition. So we have seen that even at the time of that withdrawal, if at all permitted by the NGT, nowadays they are not permitting, because they are saying that these are the causes of public interest and they cannot be allowed to withdraw. But at that time the costs are being the costs are being imposed on those withdrawal. Now coming to execution, section 25, they are executable before the civil court, local civil court. Although the executions are very difficult, we see even in the High Court and Supreme Court judgments, unless the content petition is filed, no order is implemented by the government or the authorities. So execution is very difficult. But there is one provision which helps, that is the penalty provision. That is very important, that the penalty is quite heavy, which has been prescribed under the Act. It may call for imprisonment of 3 years, 10 crore of the penalty on an individual, and 25,000 rupees for each day violation. And in case of a company, this particular penalty can go up to 25 crore and 1 lakh each for per day of violation. So this is particular thing which is very important, that the very harsh penalty has been provided, that is deterrent in nature. Now coming to section 29, that is very important, that creates a bar that no other court than the NGT can have the jurisdiction, like civil court and high court should not hear it. So many a times we have seen that the high court dismisses the petition on the ground of alternate remedy, and even the civil court exercises the power under Order 7 Rule 11, and they return the plaint that it is barred by law. So this is how it happens. Section 33, 33 is Act is having the overriding effect, and Section 34 is repeal and saving, which is very important because in repeal and saving it has been said that NET and NEA has been abolished and NGT has come into force. Schedule 1, that is very important. So one must know that in which cases the NGT can be approached. So Section 14 says that any case relating to the statutes prescribed in the Schedule 1, that is 7 different acts have been listed out in the Schedule 1. So if any case is relating to if any case is relating to those acts provided in the Schedule 1, which is the Air Act, Water Act, Forest Act, Environmental Protection Act, Biodiversity Act, Public Liability Insurance Act, if the matters are related to these particular act, then the NGT can be approached. Schedule 2 provides some of the components on the basis of which compensation can be decided. So this is how this is the whole background of the this facets of the Environmental NGT Act and the relevant provisions thereafter. Now, an interesting story. What happened that at this particular point of time, when this particular act has got assent of the president, then the NEAA has come to an end, and all the matters which were earlier pending in NEAA were supposed to be transferred to the NGT. However, after 2010, for quite a long time, the NGT has not been created. The appointment of expert members and chairperson has not been done. The similar situation arisen as it was in case of National Environmental Tribunal. And in those circumstances, what happened, one petition has been filed before the Honorable Supreme Court by Vimal Bhai, saying that one particular existing remedy has been shut down, but new remedy has not been provided. So we have left remedyless. Where we will go, the environment is being damaged and we don't have any forum to go. So in those taking stock of that situation, the Supreme Court, by way of continuous mandamus being issued on day-to-day basis, has ensured the appointment of the chairperson, the appointment of the expert member, the allotment of the place for running this particular this Faridkot house on Copernicus Mark, which is the building which we have. All those has been done under the orders of the Supreme Court. So this is how the NGT has been this NGT is created. And the first chairperson was Lokeshwar Singh Panta, who remained only for some time. He became the governor in Himachal Pradesh, so he left the job. Thereafter, Mr. Swatantra Kumar, Justice Swatantra Kumar has came, and it was a wonderful tenure of 5 years where we have seen the real worth of the NGT. So Mr. Swatantra Kumar was knowing that this is the new act, the expansion of its jurisdiction, the interpretation of its provisions, the horizons of this particular tribunal is required to be let down, and this was duly being done by the Justice Swatantra Kumar in his entire tenure. So that was a golden period where the whole law with regard to the NGT was laid down in 5 years. So till 2000, from 2012 to 2017, Swatantra Kumar Sahab was there, and now we have Justice Adarsh Goyal as a chairperson of the NGT. So this is all about the existence of the NGT. And then I will give a very brief with regard to some of the judgments of the NGT which has been passed in some of the years. I will give a small reference to it, and the list will be provided to all of you, and you are requested to go through because this is very important part of the judgment. So first, coming to a judgment of Betty C. Alvarez versus State of Goa. This is a very important case with regard to the locus standi. I will give you a brief reference of 3 cases on locus standi. This Betty C. Alvarez was a foreign national, and she has filed a case with regard to the violation of coastal zone regulation notification in Goa and various buildings being erected near the coast of the Goa. The objection has been raised with regard to her locus not being an Indian citizen. The NGT has overruled that particular objection, saying that the definition of person is very large, and therefore we cannot prohibit any foreign national also to approach the NGT. One Vimal Bhai case where a person living in Delhi has challenged the thermal power project in Himachal Pradesh. The Supreme Court has said that the NGT has said that anybody who have some concern with regard to the environment can come forward, his location or his residence does not make any difference. One particular case where the objection has been raised that the applicant who has made the application is a noted criminal. He is a blackmailer of the first order. And as of now, when I am arguing the case, the opposite counsel has said this person is being locked up in the prison. The Supreme Court, the NGT has said that even the person in prisons have protection of Article 21. They have right to healthy and hygienic air and water. We will not go in all those details that what are the backgrounds of these people. We will focus on the environmental aspect. You must show that whether the violations are being done or not. So this is how the huge arena of locus being opened by the NGT. Now, coming to this Srinagar Bandh Apda Sanghar Samiti case, this is the flood which which came in Uttarakhand. We have seen that the tragedy which happened in Kedarnath and all, and thereafter what happened that one of the Alaknanda hydropower project who have stored huge debris, and that has flooded along with the water which came, and they have said that this was the act of God. We should not be held liable for that. But while applying the principle of no fault liability, the NGT has said that you cannot escape from the liability and you have to give the compensation, and the compensation to individuals whose house and property were destroyed, around 9 crore has been imposed on particular thing. So no fault liability principles also made applicable by the NGT. Now coming to Samit Mehta versus Union of India, this is the first case where the question was that whether the NGT has the power on the maritime zone of the country, because this particular oil spill from a ship was happened at a distance of 12 nautical miles from the south coast of the Mumbai. So they have said that whether at all where some of the international conventions will be applicable, whether the NGT does have the jurisdiction or not. Supreme Court, the NGT has held that they have the jurisdiction while giving reference of all the conventions, and the transporter, the transporter was Delta Group, and the beneficiary for whom the coal was being transported, Adani Group, both were being imposed with the compensation and fine, and around a compensation of a penalty of 100 crore was imposed on them. Now coming to this very important judgment of Save Mon Region Federation. This is very important judgment of Arunachal Pradesh. What happened that in Arunachal Pradesh there is a site which is a nesting site for a bird, very endangered bird. This is black-necked crane. So these are the Siberian bird which came to that particular site, and this is their nesting site, and the local people consider them as a god, and they have their religious sentiments attached to them. So what happened that there was one thermal power project was being proposed, but while making an assessment of the environmental damage, the nesting site, the nesting site was not being considered. So this has been challenged on the ground that the entire ecology was not taken into consideration. But the other side has said that these birds have been declared as endangered species under the Wildlife Protection Act, which is not a act which is in the first schedule. So the NGT should not take cognizance of this. But the NGT has said that all the flora and fauna are a part of ecology and environment, and which is covered under the definition of environment which has been given in the act. So even if some species is being declared as endangered in the Wildlife Protection Act, but if it is being endangered in some of the project, this needs to be considered. So they have expanded their jurisdiction even in the field of wildlife protection. POSCO case, very important. This was the largest ever foreign direct investment in the country, and a project was proposed in Odisha. This was fought on various grounds, and the NGT has cancelled its environmental clearance. Same as the Goa Foundation case, and very important, this Yamuna floodplain in the case of Art of Living program. You know all that Art of Living has organized a very good, very huge program on the floodplains of Yamuna, and a suo motu cognizance has been taken by the NGT in that case. And after having the report of the committee, huge compensation was being awarded for the restoration of the floodplain. Now coming to this Rishikesh judgment, where various permission and licenses were being given for river rafting sites, the NGT has taken cognizance of that, and all those rafting sites are being closed because they have been made on the floodplains of the Ganga, which was coming in. So, and very important, one more judgment which I like to share is some there was a news cutting in the newspaper that some IFS officer in Himachal Pradesh as well as in Chandigarh has cut down some tree. The NGT has taken a suo motu cognizance and issued directions to take action against that particular individual, and as well as direction has been given to build 10 times more trees. So this is the proactive approach of the NGT which we have witnessed over the years. So this is all with regard to the judgment which have been passed by the NGT. Now few of the challenges. I think I have only 5 minutes left. Samarpit, if I am exceeding my time, please let me know. Although I am having a stopwatch in front of me and I am running at pace only. So two big drawbacks of the NGT. Yeah.
Sanjeet, when did a stopwatch stop you?
I think 5 minutes more.
No, I'm saying, when did the stopwatch ever stop you?
You can say this, bro. sorry. Yeah. So drawbacks, there are two major drawbacks of NGT as I see. First, it's locational difficulty. That's it's only situated in 5 parts of the country. And for us, like in Rajasthan, we have the jurisdiction in Bhopal. So I think that if some issue comes in the Sonu mines of Ramgarh, at the extreme border site in the Rajasthan, one has to travel to the Bhopal to file a petition. This is not the way in which we can say that the access of justice has been provided to somebody. Rather, it's very discouraging. So, and there is a huge battle going on in the south also with the southern bench, because the bench is in Chennai, in Tamil Nadu. And it has been observed by these states like Karnataka and Kerala that these 3 states are competing against each other. So there is a claim, means how far it is true or not, I not, but the Karnataka people says that the NGT tribunal at Tamil Nadu disturbs and halts all the projects which are coming in Karnataka. And therefore, NGT Chennai doesn't want the development of the Karnataka, and therefore all the projects got stayed in the, and therefore we need the separate tribunal. So there is a claim of various states, they want their own separate tribunals because the number of benches is quite limited. Second part is the limitation. If we see the limitation which is provided under section 14, 15 and 16, this is very limited, and the power of the tribunal to condone the delay is also very limited. They cannot condone the delay before that particular cap which has been provided. So once this cap is gone, because many a times we don't know what judgment has been passed. By the time we came to know that limitation always crosses, we never know that which environmental clearance has been passed, given by the central government. So once this is gone, the only remedy is to first go to the Supreme Court, get the limitation condoned, then come back to the NGT, which is very frequently happening, and that is very discouraging because limitation is very big problem in NGT nowadays. Now, if we see, these are the drawbacks. Now, what are the challenges in the present time being felt by the NGT themselves? First of all, if we see that the experts who are being appointed are not having the expertise. This is a crude fact that many a times, like almost all the appointments of expert members which have been done in past 3-4 years are from the members from the forest services. And a person from the forest services is not supposed to have all the understanding with regard to the Air Act problems, Water Act problem, waste problem, and something like that. So many a times we have the expert member in the panel, but they are not expert in that particular sense. So this is a big problem which are being faced in last sometimes. Excessive delegation to the committee. This is also a very big problem. Now the NGT is found to be in habit of constituting the committee in almost all the cases. I have been informed that there are more than 90 committees being set up by the NGT in different cases, and they solely rely upon what the report is being given by the committee. So there is an excessive delegation of work to the committees by the NGT in the recent past. If we see the overreaching executive control, this is again a big problem nowadays because the manner in which some of the last few appointments have been made by in the NGTs, although the section 7 provides that the appointment should be for 5 years or a particular age, but in last few years the appointments have been made for the period of 3 years, or any order in this regard being passed by the government. So each and every person is now at the mercy of the government to remain in the service. So this somehow affects the independence of the judiciary also. So when the act itself provides for a fixed tenure, if you keep a particular sword hanging on the particular presiding member, then it is surely going to affect its function. So this is another problem which we have witnessed in past, that the people are being appointed at the pleasure of the employer. So this is going to affect. Conflict of interest is also one of the problem, because as we know that very less number of members are being deputed. Almost all the benches are non-functional nowadays. एक साल तक लगभग ऐसी स्थिति रही कि 4 benches काम नहीं कर रही थी. Only the principal benches were working, and the proceedings for the other benches were held through video conferencing twice in a week for 2 to 3 hours only. So almost all the benches were non-functional. And in such circumstances, sometimes it happens that the persons who have passed the orders or being a part of the committee, they themselves are listening their own appeals, because we don't have any other option but to file a particular case before a particular member, he himself being a part. So the conflict of interest is also a very big challenge. So this was the challenge being faced by the NGT. But I must say that this is not all discouraging. There are very good golden parts of the NGT also, because the few good parts I would like to explain before I end my deliberation with you. In past, we have seen that we have been inspired by the international legislation. We have just copied the conventions and we have proceeded on that. The NGT is the first act which we have provided to the world. NGT is the first national level tribunal, environmental tribunal, dealing with all the areas of environment, and no other country does have this kind of adjudicatory mechanism on national level. So we are the pioneer in that sense, and we have put this example in front of the world, and most of the part of the world are studying on it and trying to have such kind of tribunal. So this is the one big part of the NGT Act. Secondly, this has been witnessed in one of the CGI, all the chief justices of various countries, 32 countries came. They appreciated this concept and they said that we also will propagate to have such kind of tribunal in their own country. If we see the level of judgment being passed by the Honorable NGT, so this has regular feature in various international media like New York Post, the Washington Post, the New York Times was regularly reporting the NGT judgments. So this is very important that we have such kind of tribunal which the world is following. I had an occasion of going to 7-8 international conference, and I met many lawyers, delegates from different part of the country, and all very zealfully listen about the NGT, and they are very happy that something is being done. The best part, I think, which NGT has done, it has created a huge awareness amongst the people. Now, if we see the industries and the corporates, they are aware about their international commitments toward the environment. Now, the environmental planning is a part of their industrial planning. So they are more conscious about it, that they have to protect the environment and they have to go in a sustainable development manner. On the other side, the marginal part of the society, the local communities, and the very grassroots people are also being aware about their right. All the big battles in the NGT were being fought by the individuals who are poor tribals, marginal part of the society, but they have brought big judgments in their name. If we see the judgment in the past of Niyamgiri case, if we see the judgment in the case of POSCO, the battle has been fought by one single tribal grassroots fellow, Prafulla Samanta, जिसने की कई सारे बड़े जजमेंट्स उड़ीसा में जो आ रहे थे, जिनके काफी सारे इम्पैक्ट थे, उसने उन सारे बैटल्स को लड़ा, and he got this Goldman Environment Award in 2017. So this is how it has given a strength to the citizen of this country to fight for environment. So the success, failures, ups and downs, achievements, losing the battles or the part of the system, we see these phases coming in and coming out, even in the High Court also. So NGT is also, sometimes we see that it is having a downfall, but this is not all discouraging. They have done a great job in our country. They are doing a great job. And the recent example, after the lockdown, when they have opened on 4th of May, On 7th of May, they have passed a big they have taken a suo motu cognizance in this Visakhapatnam gas leak case, and they have ordered the defaulter to pay the interim compensation of 50 crore. So this is the suo motu proactive action being taken by the NGT. So they are still working and proving their worth to the country. So I wish to conclude this particular thing while saying that this particular lockdown has given us a very good opportunity to have the environment surrounding us in the most pristine form. And sometimes I think that I feel the earth is also talking to us in some of the time. And one such quote I want to quote to end my discussion, that the air is pure, the rivers are clean, the mountains are visible, the chirping of bird is audible, as if the Mother Earth is saying that human is the virus and Corona is the vaccine. So by this, I wish to end my discussion, and now it's all upon to you to ask any question to me. You have all the rights to ask the question, but rights to give answer are always reserved. If I know the answer right now, I will give it to you. Otherwise, I will send my message to you. Thank you, Vikas bhai. Thanks a lot for giving this opportunity. Thanks to all to give this patient hearing to me.
Sanjeet, wonderful as usual. And this is what happens when you have such a vast experience of actual work combined with academic work. You actually have the confidence of meandering through the intricacies of the law. We have a couple of questions already come in. Others are free to write in. I think Salman had a query. Salman, go ahead. Can you ask? Can you hear us? Yeah.
Uh, yes sir. So good afternoon
Devran?
sir. So although sir आपने question का answer तो दे दिया है. So basically my question was, as you have already seen in the recent past, be it Bhopal gas tragedy or this Visakhapatnam gas tragedy, all the culprits in environmental case losses are big corporates, right? So
Yeah.
apart from including a few provisions in their CSR, corporate social responsibility, they are not serious enough to save the environment. So what are the steps which we can take as lawyers or judiciary should take to uh, to uh, to what you say
Yeah,
to bring
obviously.
in harmony, or to make them more aware of the environmental laws, because they are just concerned about their profits. They are actually not concerned about the environmental laws.
Yeah, I understand. I completely agree with you, Salman. The fact remains that this is the human nature, like the way in which the India has developed. I think that these people earlier there was this environment as a component was never being in the industrial planning. I think, but nowadays it is becoming more and more aware. And I think only those compensation and the penalties which is deterrent in nature, can make them more aware. If you see that Volkswagen case, the 100 crore penalty has been imposed. There are many cases like in this oil spill case, the 100 crore penalty has been imposed. So I think this is the only way these deterrent penalties can make them more aware about their commitments towards the environment. And this is how it is going to happen, I think. And being a lawyer, you should be vigilant about what is happening you around. You should be self-charged to reach out to the tribunal and to make out those cases and to make them liable. So this is all I think we can do in the coming time.
Thank you sir.
Yeah.
We have Gaurav who had sent another question. Gaurav, go ahead.
Yes, sir. Good afternoon, sir. This is Gaurav.
Very
So
good
my
afternoon.
my question is this: most of the NGOs now, most of the NGOs and nature lovers and nemophilists are trying to protect sanctuaries and national parks from government infrastructure projects, and many
Yeah.
of like widening of highway and dam proposal. For
Yeah.
prevention of all these things, should they approach the NGT, or NGT is the NGT has empowered to hear these types of matters?
Yeah, yeah. Your question is very interesting, Gaurav, and I must tell you that such kind of petitions are already pending before the Honorable NGT. Many a petition in which it has been said that there was a natural path of the wildlife creature being provided So or it is going to disturb the the whole habitat of the natural wildlife creature. So in those cases, the committees have been formed. The alternate ways, or the way in which these less damage to the wildlife habitats should be caused, and something has to be done with regard to the, because the we have to balance. In fact, the entity has to balance the sustainable development also. So they try to evaluate each and every aspect. If something can be done without disturbing the habitats and all, it is being followed like that only. Otherwise, some alternate ways are being provided in some of the project I know. But you are very correct that these in these matters also the NGT can be approached, and the success rate is quite high in those matters.
Thank you, sir.
We have one last question by Pradeep Khichi. Can you go ahead and ask? We're running short of time. Pradeep, go ahead.
Hello, sir. Thank you so much for an amazing lecture. My question pertains to the proportionality principle. Does the NGT follow the principle of proportionality while imposing hefty fines upon the corporation? Like even for the minor violation of an environmental law, they would impose fine of 10 crore, 15 crores without taking into consideration the capital market or the financial capacity of the corporation.
Very tricky question by Pradeep. Actually, as a matter of fact, I told you that this particular concept of evaluation of compensation in the cases of environmental damage is not very foolproof developed in the country. So even I have seen that in most of the judgments, the penalty of 100 crores or something like that, or 10 crores or 15 crore being imposed. But I fail to see those criteria, those discussions, and those findings in the judgment in which they have discussed that how it is justifiable to impose this kind of penalty, whether how it is commensurate to the damage already caused, and whether the particular industry is in position to pay those things or not. So these discussions are missing, I think, in those judgments. I
I'll
think,
just add on, it's a classic
yeah,
case of how misplaced our notion of expertise is.
yeah,
Sanjeet
yeah,
had
yeah,
very pointedly pointed out that the whole expertise thing is sort of skewed when you have only, say, forest people coming in into environment. So even within, say, for example, air, somebody who understands ambient air may not understand the air which is around the sea, and it's such a super
yeah,
specialized. So you can actually never have that specialization. And
yeah,
unfortunately, our policymakers have their own sort of vision or lack of it. That these question, there's a very pertinent question that you pointed out. The question of monetizing, which is in effect, giving compensation, or the proportionality of it. It is essentially an expertise function of finance and economics.
yeah,
And most environmentalists, environmentalists do know, like that's a very broad word, but the most kind of an experts that are available who are from the technology side have got no gumption of how a valuation is to be done. There the principles of valuation will come in. For example, if some damage has been done to say because of a mining area, and you've lost out, say, on a species, they are not in a position to evaluate the cost of the loss of species. You only
yeah,
evaluate the cost of how it will be restored, the
yeah,
physical cost, etc. Even very classically, all our natural resources are priced based only on the cost of excavation, transportation, publicity, management, license fee, royalty, etc.
yeah,
Nobody builds in the cost of opportunity lost, of the nature's cost of a million years that it takes to build that resource in the earth itself. All those are missing, because essentially you have not reached out. You think you, in the sense, the policymaker thinks that the only kind of experts that are required for environmental issues are environment technologists. No, you will need an economist, you will need a financial guy, you will need a lawyer,
you
because
are
each
absolutely,
one has a different function. And that is why your whole compensation mechanism in laws, that sometimes it is too less, so the person who has violated the environment is really not punished at all, and sometimes it is so large in a place where something, say for example, it is done by mistake. it's so large that it is not commensurate with the mistake. Both extremes you will find. And yes, to get a balance is extremely difficult, but there has been no serious attempt at that, because there are proper methods of evaluating, but those are not employed at all. uh,
Yeah,
any
Vikas
more
bhai,
questions?
absolutely, absolutely true. In the last my visit to Philippines to attend one of such conference, there was one session by the economist also, and at that point of time, we have congratulated the organizers to for their vision that they have called some of the person from economic side to discuss these environmental matters, and we felt that there is a need that whenever the issue of the damage, they should also have the economist in the team to assess the so as to develop a law on this point.
I think there was one add-on of a same question by Arushi on the Aravali. I'm not sure what a question is. Uh, Proportionality for Aravali. Why don't you go ahead and ask the question, Arushi?
The greetings, sir. So my question is, what is your take on ongoing illegal construction of hotels and other properties and excavation on Aravali Hills? I would really be glad if you address this in the light of how a complete ban over such activities can be brought, as we have seen that there's an enormous construction going on, be it Aravali, the Udaipur and Ahmedabad highway, or any other construction of hotels or properties across the Aravali range, ranging from Gujarat reaching to Delhi. So, what is your take? Because it is diminishing day by day.
Very true, Arushi. First of all, I would take your pardon for the reason that there were many ongoing matters on the Aravali region. There was many judgments in Deepak
Yes,
case, and all very judgments have been passed. But I'm not updated with regard to the present status of those proceedings. So I will complete my research and will let you know. And your concern is absolutely justified that something has to be done. These things are not going to happen again. These are the one-time natural resources. Once we will lose for all times to come. We have to
yes,
maintain the generational equity. We need to preserve something for our next generation. So all this is required to be done. The present status I will let you know, and
sure, sure.
all we can do is to, being a lawyer, we can file petitions. That's it.
So,
Sure, sir.
Trace somebody, some murga for us. We are all free in the lockdown. We are ready to draft a petition to put online in the NGT. We're waiting for that.
Sir, I'm already working on this petition actually, and that was the reason I wanted your insight over this topic.
You are most welcome to call me at any point of time. We can discuss
Sure, sure.
something. If I will be happy if I can contribute something on that.
Definitely, sir. It will be all my honor. Thank you so much, sir.
Thank you. Thanks a lot. Yeah.
so lovely session. I think we are at the end of our time. Thank you, Sanjeet, once again
Thanks a lot, bhai. Thank you for giving this
for
opportunity
putting
to.
this together for everyone, and for taking the initiative of Legalsphere forward. I think all of us together can make it a very vibrant body. Thank you everyone for joining in. Hopefully, you are having at least some good inputs for the locked out periods. If anybody has any suggestions or want to take a session, feel free to write to me. Tomorrow we have Sunil Beniwal. Can you hear me?
Yeah.
Yeah, tomorrow we have Sunil Beniwal on something very peculiar, which is, we come across it every day, but most people really don't understand it. We hear it, but we fail to understand the intricacies, which is the documents under the Land Revenue Acts, how to read them, what do they mean, what is the purpose they serve, and the nomenclature used, because the nomenclature is so peculiar. All of us, even our Hindi and Marwadi speaking people, a lot of times don't really know what they mean and why do they mean. So Sunil Beniwal takes us through those intricacies of documents. It's a continuation of if some of the people who had attended Baljinder's session, who had spoken on a general overview on the land and revenue laws. This is an extension and getting more specific and more in depth on some particular areas, which is the documents and the terminology. So tomorrow we have that. And on Tuesday, we have Jay Lodha from Jaipur talking to us on insurance law in India. So those are the next two things we have lined up. Thank you, everyone. See you tomorrow. Bye.
Yeah, bye. Take care.